Hey, it's another exciting video from yours truly, Brian Parker from Collection Stopper. Everything you want to do a debt collection defense practice is probably in podcast plus on my website, Collection Stopper. I've been told I have to do this earlier. Please subscribe and like. And if you like the information now or later, please subscribe and like. We have a goal of 500 for the month of September, and we're 4 days away. My material is sometimes it's up there, sometimes it's down. I've had some stinkers, creative stinkers, but we're getting better. So subscribe and like, and let's see if we can get to 500 subscribers. Hey, I mention a lot, two things. This is being given under the auspices of education, information, and sometimes entertainment. I'm not your client, but I am your friend. In that, friends support one another and help each other out. And I believe I'm doing that, a good service for people with all the free stuff on my website. If you disagree, I don't know what else I can do, but I'm just going to keep coming with the good stuff. And the good stuff we have today is what I mention constantly, other than, the last video I talked about the A.S.S component, and people love that. We're going to do an A.S.S component again today. And again, it's clean family living. It's nothing untoward or provocative, but somebody will be getting messed up. I'll leave it at that. You want to mess them up a bit. What do I mean? The Account Stated Statute, A.S.S, Account Stated Statute, is invoked 90% of the time at least in collection lawsuits. That's important because most collection lawsuits, I haven't seen a collection lawsuit with the actual signed contract in a very long time. With credit unions, I get a lot of those that they have the actual installment agreement, but those are few and far between. Generally, the Account Stated Statute, which is in most states, but with different variations, is a way for the plaintiff collection company to not have a contract, but they've got to allege an account stated. They throw in breach of contract, but they don't attach the contract, but that doesn't stop them. And generally, collection lawsuits around the country are account stated, breach of contract, and then unjust enrichment is commonly thrown in, which has a variation of breach of contract, inferred contract, implied contract, open contract, depending on what state you're in. I'm going to try and be vanilla about this and again be Michigan centric. But an account stated complaint using the A.S.S, Account Stated Statute, must allege that there's an agreement, an amount is owed, peripherally, that either the card or the debt was used, but it is required in an account statement, especially in Michigan, the parties expressly agree upon the sum due, and the party receiving the account does not object within a reasonable time. Now, listen, the objection within a reasonable time is pretty much what you see state to state, even when in some cases like Florida, they don't actually have specific statute compared to Michigan, which is MCL 600.2145. As an attorney, in fact, there are TV shows that are called The Practice, and that's what we do. We practice. And when you graduate, you want to get out there and start practicing, but you don't really know or understand what that word means until you've looked at something for the 50th time and see something you never saw the 49 other times. It's just using something and rolling around in something and ruminating in statutes and things that you use. Stuff pops up. And with Michigan statute, I'm going to tell you something really cool for defendants and defense attorneys defending against these lawsuits. But we're going to mess these guys up. Remember that. We're going to mess these guys up. Brian P. Parker. Brian Problem Parker. So be the problem maker. And today we're going to show you an account stated defense so we can mess them up. But one of the small things that you see but don't see, but then suddenly you do, is an account stated statute, when used in a contract, it's unusual how the actual elements of an account stated claim are properly invoked. So we're going to look at that today, and we're going to have a lawsuit, and I'm going to show you how specifically you match that lawsuit up with an account stated statute using what we talked about in the last video about the new changes to the validation request rules, and also the account stated statute, and a little extra oomph that I recently learned and I'm putting into all my account stated affidavits. So it's hot off the presses. I'm going to give it to you right away. But an account stated lawsuit, which most collections lawsuits are, says usually they have an account affidavit attached to it, because by the time the debt is defaulted and is being sued upon, the contract is long gone. The original creditor either purged it or didn't sell it along with the debt that it sold to the debt buyer for pennies on the dollar. So if you read a lot of the agreements, and I do, between the original creditor and the debt buyer, they all say, hey, look, buddy, you're paying nothing for this debt. We make no representations about if this is going to work, if the person's collectible. We're making no representations. And that's usually in what's called a purchase forward flow agreement. Ugh. But that's important. That's the stuff where you go, ugh, I don't want to read that. Then you realize, hey man, that's really important. Most bill of sales, which are attached to a lot, if not all, bill of sale, account stated statute complaints, have this incorporated inside every bill of sale to say, this is being sold and purchased pursuant to the forward flow agreement. It's sort of a secret document that will never get attached to the lawsuit. So you, as an enterprising problem maker who wants to mess them up a bit, demand it and say in your affidavit, for the counter affidavit, hey man, they're talking about this. They're saying they own it pursuant to that, but it's not attached to the lawsuit. So that's one of those things we're going to talk about briefly later on. But this 600.2145 Michigan's account statute says, and keep in mind, most of them say this, if you have an account stated affidavit attached to a lawsuit and you, defendant, answer the lawsuit, but you don't do a counter affidavit, it is, and this is legal, but I'll tell you what it means. It's deemed, you can understand this, it's deemed prima facie evidence of indebtedness. So when you go and use a solo suit or a company that does the quickie answer for you, none of them really advise you that, particularly in certain states like Michigan, you must have that account stated affidavit, counter affidavit, or the law is it's deemed prima facie evidence of such indebtedness. I just thought of a way to get out of that, even if you don't do the affidavit, because my freaking brain. So you have to do a counter affidavit. So you go to my website if you want, look at the hundreds of examples I have. I'm not telling you to use any of them. If you want to use them, fine. They're just there for viewing. But there's a word here they use, prima facie evidence of such indebtedness. When you do a lot of this debt stuff, there's actually three ways to look at debt. There's the debt, the indebtedness, the servicing rights, and there's any other part that's been sold of the debt, the receivables. So the indebtedness, while I think the legislature was going, that means debt, it doesn't. A lot of times you'll see the debt collector who doesn't want to admit that they don't own the thing. They'll go, hey, we own evidence of indebtedness. Well, if you have to put a preface or a word before the word you're relying upon, that's too much. So evidence of indebtedness is not indebtedness, and it's not even the debt most of the time, because most debts are chopped up and either securitized or sold in what's called tranches. Not necessarily that's applying to debts, but it's broken up, baby, especially when they sell it and they've already securitized. So when they say evidence of indebtedness, that means someone wrote on a piece of paper, you own this. That is your evidence. But if you don't do a counter affidavit to whatever schlock they're bringing, it becomes prima facie evidence. But again, I'll get you out of that. But I'm not going to always be around. Now, here's the cool thing with the statute. You have to say in 10 days of you receiving this affidavit attached to the lawsuit, you have to say, no, I don't owe that debt, or you don't own it. The amount is wrong. Whatever your rationale, have it be big and strong. I always say, as you will see today in my affidavit, defendant disputes as stated, because they never are clear in their lawsuits, because they have to write it generally. If they don't have a general one-size-fits-all lawsuit, then the many thousands of lawsuits that go out weekly from a big debt collector will slow everybody down. So they just change the name, change the creditor, previous creditor. Hey, this was assigned. I know a debt collector that files lawsuits, 1,000 a week, with 4 paragraphs, with 4 lines. And that's how I slam them, because they're always wrong, or they say the wrong thing. But for the most part, because 90% of these things get defaulted anyway, and we're working on that together, they can put out whatever garbage they want because no one's really checking. It's just that 10%. And then I come along in that 10%, and they get really mad. But in that statute, it says if you do your counter affidavit, you're good, you're golden. You get rid of the prima facie evidence of such indebtedness, meaning prima facie means you owe it. But for the amount that you owe, this case is done. So that's a serious thing, a result to happen if you don't do a counter affidavit. So when you go through one of these solo suits or these companies, which I'm for as far as stopping defaults, you're actually hanging yourself, because you're just setting the court and the plaintiff up to say, where's your affidavit? It's better than a default, but they're just going to come right in with a summary disposition. You're going to get overwhelmed because you don't have this counter affidavit. So that's everything, man. Within a lot of these statutes, state by state, especially in Michigan, you can create your own counter affidavit, like I said. But here's the cool thing. If you can come up with a way to mess them up by saying, hey, you shouldn't have sued me. You were wrong. You didn't bring the proof. Under the FDCPA, you owe me $1,000 under the, let's say, Michigan Collection Practices Act, $350, plus my attorney fees and costs for having to do a counterclaim and an answer to a lawsuit that shouldn't have been brought. You owe me $5,000. If they don't answer, and this is the thing that just dawned on me after 30 years, if they don't answer your counterclaim affidavit within 10 days, then they are on the hook, just like you are. If when you initially get sued and you don't counter affidavit within a certain amount of time, you're on the hook. Now they are on the hook. And the only thing that's left with the counterclaim is to see how much they owe. That's the only thing they can dispute. Because if you file a counterclaim with that counter affidavit, it's prima facie evidence of the indebtedness of the folks that sued you. They're now the defendant. So they've got 10 days to come up with a counter affidavit of their own. So what do we do when we fight? The best fighting stance is on your heel. And the best person to punch is if they're on, when I say on the heel, you're leaning forward. So you're actually on your toes. But if the person that you're about to hit is on their heels, they're going down. You just need one punch to the solar plexus. My point being, you've turned this fight around where now you are the attacker. And now they're flailing backwards because you just relied on the law. Another thing, when they file their counter affidavit, sure, we want to do a counter affidavit, but I would advise you to do something very cool. They pump out these complaints. Boom, 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 boom. The person that does the account stated that's going to be attached to the lawsuit is sometimes in a different state or in a different floor, but they're not the same place. They're not in the same place sometimes. So you'll have a Michigan lawsuit and a Virginia affidavit, a Michigan lawsuit like in Midland Credit Management, and a Minnesota affidavit. All their affidavits, no matter where they're filed, Minnesota. It's like a mill out there. We won't get into that. So what am I telling you? The statute says you have to have a date on the affidavit that you file, and it must be within 10 days of the filing date of the lawsuit. 10 days isn't so long if your stuff's in Minnesota. So I don't know the last time that I saw a lawsuit with an affidavit that was 10 days old or less. They all, sometimes 2, 3, 6 months, because they've got so much to sue and there's a backlog. And these two states and these two departments and these two companies, sometimes different companies, they'll say, hey, I'm Bob, I'm the servicer consultant for XYZ collection company. Here's the affidavit. I know it all. Well, they didn't get it to the Michigan plaintiff within 10 days. The rule says you got to do it within 10 days after such service in causes in the circuit court before trial in other cases. So if it isn't coming, if the date, so this is what I want you to do. Get a lawsuit against you. You get their affidavit. Look at the date that it was sworn to, and then compare that to the date on the summons, not on the lawsuit, because they'll file the lawsuit, let's say May 15th, but the summons, meaning officially filed, will say maybe June 1st, because while they wrote it on May 15th, they didn't get it in on time until June 15th. So compare the summons dates to the affidavit. Now, I would never say, hey, that affidavit is gone, it's dead because it didn't make it within 10 days, so don't do your counter. And you're going to see right now why we do the counter either way. You got to do the counter affidavit, but I'm just telling you, if you do face a summary disposition, it's going to be on that account affidavit that they brought. That's the only proof they have because they don't have the complaint. Now, they're going to have account statements. I may do a video. Those statements that you get monthly, there's some thought out there, and I'm not going to go any further, that they're not evidence because they may not be complete and they may be fractured pieces of copies that have been put together. So technically they're hearsay, and that's a whole nother thing. So the reliance then on the affidavit is everything. And if it's 10 days or 11 days old or greater, it's of no use. So these are little things that you pick up along the way to mess them up a bit. You need to attack the prima facie demand of the lawsuit with your own counter affidavit, and then counter that, hey, you guys owe me money and you've got only a certain amount of time to get back. I have never seen a counterclaim response with an affidavit from the people, the debt collector that I'm counterclaiming against, They've never done their own affidavit. Think about that. It's a machine. They can't call up Minnesota and go, we need a counter affidavit to counter the lawsuit that we filed. It just doesn't exist because their whole thing would collapse. So do this. Be a problem. Mess them up a bit. In Florida, it's a similar thing. I practice in Florida too, except they don't have a real account statute where you can put a number, a code onto it. And their rules are the elements of an account stated claim are a little different. A previous transaction that created a liability. That can be a contract, credit card, loan, goods and services. And secondly, an agreement by the defendant, that's you and me, that the balance is due and correct. A promise has been made either expressly or implicitly to pay the balance. And 4, the balance remains unpaid. So that's a little bit more burdensome. I would come in with your account stated affidavit either way. There's only 3 ways to overturn an account stated lawsuit in Florida, which has a similar standard. When an account statement has been rendered to and received by one who made no objection. Listen to that. We just talked about how you must object with your own counter affidavit. In Florida, been rendered to and received by one who made no objection within a reasonable time. Then what happens? A prima facie case for the correctness of the account and liability of the debtor. So a rose is a rose is a rose here. The language is different, but 2 things are true. If you don't counter with proof that you don't owe the debt, in Florida it says you don't object, then both cases, a prima facie for the correctness of the account, or in Michigan, prima facie proof of the indebtedness of the defendant. Either way, you got to object. So in Florida, they're a little unusual the way they do things. The account is presumed to be correct unless you can show fraud, mistake, or error. So pump that counter affidavit up a bit if you have evidence of fraud, mistake, or error if you're in Florida. Here's the cool thing. Now, I just did the video for validation. It was a 52-minute video. It's tough getting through, but then I'll talk to somebody about it and they go, it was great. I got this. So maybe it is good. I see it 7 times because I have to keep going over and over it. But my point being, let's include the validation requests in the counter affidavit that we're creating. So what are we going to do? We are going to throw pages away, and our first lawsuit I want to put up is a Citibank lawsuit. So Shazam Citibank lawsuit, and you'll see page 1 of the complaint. And again, you'll see this communications from a debt collector, anything you use or we used against you, blah, blah, blah. And on page 2, it'll say the same thing. Put up page 2, Shazam. And you'll see on the bottom, this is a communication from a debt collector. We're attempting to collect a debt. Any information obtained will be used for that purpose. Now look, I talked at length about what that means yesterday. They just made Citibank a debt collector, which they are so protected from the FDCPA because they're creditors. But 2 things, securitization, they've sold the debt, so they're really collecting for somebody else. This confirms it. The debt collector will go, no, we put that there. Doesn't matter. The debt collector's not in the lawsuit. Only Citibank is. So that's their pleading. So they are debt collectors. So we have to mess them up a bit. So the first thing I'm going to put up for you is how to counter a creditor, or in this case, a Citibank lawsuit. And we're going to go Shazam, the affidavit of John Q. Public, and a Citibank represented by Stenger and Sanger. So I'm going to leave page 1 up for a bit as 1 on the bottom. Look at the little asterisk. Your affidavit, let me just tell you what we're doing here. I'm going to show you how and why these things are in a counter affidavit. It'll make more sense. It'll be more fluid when you do it yourself. So if you're a Citibank affidavit, you'll know why I do it and why, if you choose to do it without me telling you what to do, you can do it. But if you look at number 2, I dispute I owe this debt. Why is that in there? Because we're not disputing the amount, because that's not good enough. Remember we talked about with motions for summary disposition, you must show a material dispute between the parties or you'll get stomped on by the collector for not having enough to get to the next stage of the litigation. So I say I dispute I owe this debt and the amount. And then I'll say the court, let's look at the affidavit again. Number 3, the court can see from the lawsuit there's no paperwork or documents or credit holder agreement. Number 4, this is a good one. Hey, it says this is a communication from a debt collector. We're attempting to collect a debt. This, and then I'll say right in my affidavit, this clearly is an indication it was securitized and that Citibank is a debt collector. Where's my validation letter? So then I put it in, if you watched my video yesterday, I'll put it right in the affidavit, number 6. I'm entitled, I'm asking for money damages in number 6 as my counter affidavit. Now they have to do an affidavit to stop you. But in a lot of my affidavits, I'll say right in there, I want my validation request. I want, like in this one, I said, I demand that plaintiff validate and verify the debt under 15 U.S.C. 1692 and prove to me that Citibank owns the debt. A debt collector that contacts you and does not validate the debt is facing a lawsuit and cannot prove their case. I'll bring it into the law, even though we talked about yesterday, a collection attempt and a lawsuit are separate. I said separate entities. I don't know what I meant by that. Unless there's a bridge between the two, which is putting the mini Miranda in the lawsuit. That thing, we are debt collectors, anything you say will be used for that purpose in the lawsuit, is the mini Miranda. That means it's a collection communication. So they've taken their lawsuit and they're immune from validation requests by law. But when it becomes a collection lawsuit, it goes into the collection attempt pool where they must validate the debt. And Citibank hasn't sent out their mandatory statutory rights to the debtor that all debt collectors must do, because they're like, we're creditors. We never do that stuff. Yeah, you do. You even told us you're debt collectors. So that's some fun things where you can mess up the creditor. They're just loving me. So the next one is against a debt buyer called Portfolio Recovery Associates. That's just as big as, or big, they're actually publicly traded. Portfolio Recovery Associates out of Virginia. And they are, as I said, they're trading on the stock exchange, huge company by billions of debt for pennies on the dollar. And they are usually represented by a company called Weber and Olsey, at least in Michigan. So I'm going to put up page 1 of the affidavit with Portfolio Recovery Associates, Shazam. Page 1, you can see what I did. I dispute I owe this debt to PRA as stated in the lawsuit. So I got that off the bat. So no judge or anybody is going to go, well, did they dispute? Are they claiming they don't owe it? It says it right in my counter affidavit. Page 2, Shazam, page 2. You might want to do this. I'm not telling you what to do. I take their paperwork, as you know I've said many times, take their paperwork and use it against them. In this case, you can see their bill of sale with a number of companies all claiming to sign off and own this debt at one time, with the names A.S.S. Holding LLC, Synchrony Card Funding LLC, Retail Finance Credit Card Services LLC, and a number of other things inside the bill of sale. And you can see at the second line, the forward flow accounts purchase agreement. That's always in these bill of sales, but they're never attaching it. So ask for it. They'll give you some crap. Then they'll want to settle because they don't want to give that up. But it is securitized, as I've written on the page. That's why these companies are in there with the funny sounding names. So that means somebody else has the debt, had the debt, passed the debt. So these 6 members, including Synchrony Bank, have to show you an assignment between all of them. Because why? It's all about the assignments, baby. So in my affidavit, page 2, I say at number 3, there are no assignments attached to the lawsuit from Synchrony Bank to any of these entities in the bill of sale. Say it right so someone's going to read it. It goes with everything you do. It goes with your counterclaim. And then the next one, number 4, on page 2, I say, where's the forward flow account purchase agreement that they're relying upon? Now, we talked in terms of elements of an account stated claim. So I go for the jugular. Number 5, page 3, Shazam. I say I've not paid anything to PRA or come to any agreement, which is part and parcel what the elements are. So we're arguing our case when we're just following the statute. Don't just follow the statute. If you know Parker and his answers, he doesn't go deny, deny, admit, denied, neither admit or deny. He gives you a story, man. Well, that story emanates from the account stated, which has legal ways to help you win your case. Number 6, my research indicates that the debt has been placed into a secure trust by Synchrony Bank and has not been returned to Synchrony Bank by the trust for it to legally sue me. What am I really saying? They don't have standing. They don't own the debt. By the way, attorneys listening to this, do not have your clients just sign that. I provide my clients with proof of Synchrony's securitization of the debt, and I won't let them sign it unless they say to me they understand what securitization is, because otherwise it's not an honest affidavit. I don't want my clients signing anything unless they understand what they're saying. So there's work here. And again, I use the concept and term 1 step backward, 2 step forward. Take the time with the client, or if somebody's representing themselves, go in and put securitization of Synchrony Bank in Google, 10K financial reports. You'll have everything you want to know in 5 minutes. Just do Control F into the financial documents. You'll see everything you want to know about securitization. So my clients don't sign this unless it's the truth. Number 7 on page 3, you can see this is this new thing I'm putting in my counter affidavits now. Hey man, you sued me incorrectly. You owe me $1,350 and $2,500 for the attorney. It's a sum certain. Now, if they don't do a counter affidavit, which they won't, I've never seen it, they owe, you won that case. You won the counterclaim. All we get to talk about per statute, per law, is how much. The law is there for you, not just for them. And that sometimes when we're being sued, I've been there, it's crushing. And maybe that's what it's supposed to do. And step back a bit. And again, the concept of punching someone, if they're right in your face, step back so that you can push forward. Well, when you're being sued, step back. Don't feel crushed. Step back. Okay, what's going on here? And with these instructions, you can tell what you need to do to fight back and settle the case. I'm getting out of creditor cases now, I'm getting the debts eliminated just using this stuff. It's out there to use. That never used to happen. Now, here's a cool thing. Remember I talked about how the dates on the affidavits are not current enough? They have to be within 10 days of the filing of the lawsuit, and I never see it. That's one hole. It's a brick. It's not a wall, but it's a big brick. Another one is writing the affidavit. You guys are gonna think, oh, lawyer, technical BS. Listen to me. Their affidavit says, Bob, Midland Credit Management plaintiff, Bob Jones, defendant. They create their own lawyer-looking like affidavit, and then they'll talk about the defendant does this and the plaintiff does this. Why do they do that? because they can't keep reinventing the wheel thousands of times. Midland Credit Management and PRA are pumping out thousands of these. So they can't do what I do, which is I conform everything I do to the person and the facts. I don't have a template per se. I do have a template, but it's full of real applicable facts of the case. They can't do that thousands of times a day. So they'll make a template and say Bob is a defendant, Midland Credit Management or PRA is a plaintiff. Well, they're not, because the affidavit is always signed before the lawsuit is filed, not after. So if they say they're plaintiff and defendant, there has to be a lawsuit. You're only a plaintiff and a defendant when there's a lawsuit. So they sign this under oath. Now, this is picky, but it's not. They have to say under oath that everything they have just written, that's the affiant, the person that's signing, that, hey, judge, we don't have the contract, but we swear under oath that he owes it, and here's why. If you're calling someone a plaintiff and a defendant when no lawsuit has been filed, and it hasn't, it can't be. In fact, the lawsuit is not filed or even written until that affidavit is done, then you've, for lack of a better word, you've lied under oath, because Bob Smith isn't a defendant, Midland Credit isn't a plaintiff until the lawsuit is filed. So if they lied that way, judge, they're lying other ways. You don't just joke about signing something under oath, and that is about credibility. So it's in my affidavit. I'm not a defendant. They're not plaintiffs until they file the lawsuit. That's number 3, page number 3. In this case, on page number 4 of this affidavit, you can see, and this happens, man, it doesn't happen as much as it used to. I'm alleging, I don't know for sure, this case will probably get settled pretty fast. That does not look like, put up page number 4, Shazam, look at that signature. That's like 2 people, or it's like some right hand and left hand signature. It's fair of me to say that's a suspect. And I wrote on number 11, the signature on the affidavit does not look real, and you can clearly see it was cut and pasted on the document. Oh my God, that's not even close. I hadn't blown it up till today so I could read without my glasses. Boy, is that bad. That's not even close under oath. So you can settle a case just with that alone. So I advise you with the summary motion video, tear the motion apart. Get your pen, get your highlighter, and just break it down. Inch by inch, anything's a cinch. So we're overwhelmed, break it down. Inch by inch, anything's a cinch. So sit back, and you don't always have to nail it, just boom in the solar plexus, and it's the same effect. So we want an inch. And then sometimes in this case, this is just one brick, but I think that's the whole wall. If your affidavit, and this is the signed, sworn under oath affidavit, is that, I don't know what that is, and it may be whoever that person is, their actual signature, but clearly that was cut and paste and put into, in my opinion. And you're talking with somebody, during the foreclosure crisis, 2006 to 2012, it's all I did all day long was compare signatures. Had thousands of them, walls and everything covered. And I pretty much learned who nationwide were the robo-signers in that foreclosure crisis. A real quick, I got to be careful about this. But after I went through that, I just knew everybody's signature and every fake signature. That was just thousands of them. A friend of mine was proud because they paid off their home. And they wanted to show me what it looked like. Hey, look, house paid off. And they presented me with the legal document that said, this has been paid off. Let's just say it goes like that. And there was the signature of one of the biggest, robo-signers I'd ever come across right on their document. I knew it. I saw it. It was a variation 6 times, 6 degrees removed from that person's actual signature, and he's gone away. Stuff happened to him because of it. And there it was. What do you do with that information? Do you tell them? Certainly not. And a lot of the stuff, a lot of the homes have these documents with these signatures. We just can't go there. So I got it. I can pick it real quick. Something that looks kind of weird or cut and paste or robo sign. So you look and see. Just for the record, I'm not saying there's a robo signature here, even though I've got robo signer ? Because to me it looks suspicious. But I may be wrong. That may be how the cut and paste signature is. But you need to put that right in the affidavit if you see it, if you've broken the affidavit down, if you've broken the lawsuit down. These are allegations that I'm saying right now. This may be all good, but that's what a lawsuit is. They're alleging something, and you're alleging something right back. Who knows if it is or not? It looks strangely contorted to me. So that always goes right in your affidavit. Tell the court what's going on, because the judge gets a lawsuit and you're already suspect. If you come back with a counter affidavit and telling your story, it's better than a cut and paste affidavit that they've attached to their lawsuit. It's so much better. Yours is a story. Yours is fact-based. It isn't like you just saw where there's possibly a cut and paste signature with information calling you a defendant when that isn't the case. You have to look at these things from a human standpoint. If I see a story, I'm going to read it. If I see a template, I'm going to go, So bring someone's attention to your good work and your claims will be respected. That signature, while it, for the record, it may be totally cool, brings suspicion just from looking at it. It's a mess. And you can see lines that shouldn't be whited out. Why is the actual signature have pieces whited out? Let me grab it again. I threw it. Yeah, there's pieces whited out. It just begs for me to say, hey, there's something wrong there. So look for something wrong there. Mess them up. Lastly, I just want to do a quick thing and a little hint for you. Discover Bank will oftentimes sue. Let's go affidavit for Discover Bank, Shazam, page 1. And if you look at paragraph 1, I don't know why Discover does this. They just causing themselves problems. They'll go in their caption, Discover Bank, Discover Products, Inc. That is already telling me something's going on there. So I will allege in my affidavit, page 1, there's no signed agreement proving I owe this debt to Discover Products with Discover Bank in the chain of title. Well, clearly something's up. Why is that in the title unless Discover Products has ownership? That is indicia, that's a legal way, but it's indicative of some kind of securitization. Discover Bank itself, while it sues 1,000 times a day, to me, on my research, is nothing more than a servicer of a trust. I think it's called Discover Funding, LLC. But having the word, and so I allege in number 9, I did not sign up with the company Discover Products, Inc. and don't know who they are and why they're on the caption of the lawsuit. So you're putting a rock in somebody's shoe. That it's going to cause an irritation. That someone's going to go, wait a minute, yeah, you're right. In number 13, it's page 2. I haven't written page 2. Shazam, page 2. I write in number 13, my research indicates that the debt has been placed into secure trust by Discover Bank and has not been returned to Discover Bank by the trust. I make sure that my client has looked at the paperwork that I provide them and says yes and signs their name to that if they believe that to be the truth. A real quick tip, in this case, the person was sued in a county they don't live in. That's FDCPA 1692I, says thou shalt not sue someone in the wrong district, court district. That's $1,000. And so when they do that, I want it right. I want my story in my counter affidavit. I am countering their affidavit. They give you so much meat to put on your bone of counter affidavit that you'll get a great settlement or get the debt eliminated. All right, so I don't know how long this one's going. I tried to do 30. I got to tell you this. I'm sorry if it goes longer. You can just fast forward to the good parts, which these are. Check this out. In some states, like in Florida, it's a 4-year statute of limitation on an account stated complaint. Well, the open-ended credit card is 5 years. So if you're suing on a counter affidavit claim, do you eliminate a whole year of does the plaintiff kill itself for a year when it could have sued for 5 years because it brought an account stated claim that it had to do because there was no contract available to cite a breach of contract? And the other way of that, if you're in Michigan where it's 6-year statute of limitation on a account stated claim, and you use the affidavit for an account stated claim, but the paperwork attached to the creditor who the debt buyer bought from, or even the creditor, let's just say it's Citibank, some of these companies, it's sort of legacy. They stopped doing it when we started catching them, but they set themselves up in states with 4-year statute of limitations. So if you get sued for a debt on most claims are, check this out, most claims are 6 years in Michigan as far as debts. If you do a account stated claim, and that's a 6-year statute of limitation, but the contract is out of Delaware, which let's say it's a 4-year statute of limitation, or California, you are bringing a claim and extending. So they may be suing a year or two after the statute of limitation has been eliminated. So look at if they have a cardholder agreement, make sure, make sure, I talk too much, that the statute of limitations is obvious because the account stated statute is 6 years. Do you have a right, is the question, to extend a statute of limitations 2 years by bringing a claim of 6 years when the actual contract says it's only 4 years? You know what I'm going to say. Sorry, Charlie, you lose. But that's something to look into. Look at the actual contract language. You're never going to see it. You'll have a template in most cases. So go online and look for the year that you signed up for your credit card, and you'll find the cardholder agreement. It'll say where it's out of. If it's out of a state that's 4 years or 5 years, and they're suing you in after that using an account stated, they're extending it another year when the actual agreement does not have that. I hope that makes sense. So look into that. Always tell your story on a counter affidavit. Always say in the counter affidavit, my counterclaim means I get a certain amount of money because you broke the law. If they don't answer that with their own counter affidavit, you're right. It's just a matter of figuring out how much. Prima facie evidence. At worst, if they do a counter affidavit, they'll give you more information to protect their ass. And we've talked about that before. Why do debt collectors do stuff that hangs them? Because they're seeking to cover up something else, like a securitization or something else that's going on, some CYA. So if you can bring them out a little bit further out of the woodwork with a new counter affidavit, they're going to have to put new information that helps you, because they always do, hurt them. So it's about objecting to the thing against you, whether it's Florida, where they demand that you object, or Michigan, where you, by statute, have to do a counter affidavit. These are fun things to mess them up with. Take your time. Don't let it crush you. Step back, arms up, and then have your own blows so they're on their heels. You're good. You're smart. You got this. Check out collectionstopper.com, podcast plus. I hope you like this. I hope you subscribe and get us to 500 subscriptions. And I thank you very much. I hope I've helped you. I'm real passionate about the counter affidavit. It's the lifeblood of everything you and I do. It's all about the counter affidavit. It's all about the assignments. It's all about telling your story. It's about setting them up. So go out there and get them. Use my free stuff. And I thank you very much.